Hi, I'm Kenny. In last video, I talked about two rules for the duty of procedural fairness: the right to be heard and the right to fair and impartial decision making. In this video, I'm gonna talk about another rule for the duty of procedural fairness: processing without undue delay. And probably this would be the last one I would discuss about in this set of videos: the law basics in Canada immigration. Again, I will explain this requirement through a case study. Now let's start. In the way of applying for Canada immigration or a visa, many people are very anxious and would like an immediate decision, certainly most favorite an approval. But in reality, quite some people encounter a situation that they just wait and wait and wait. It seems their applications just take forever before a decision is made. So they tried their best to contact the IRCC through the web form or make telephone call every month, every week, or even every day. But there is still no news. What can you do in this case? First of all, let's look at the law. This is Article 72. It's about judicial review. It stipulates that a decision, determination, or order made, a measure taken, or a question raised under this Act can be applied judicial review upon. Therefore, this article in the IRPA about the judicial review provides us a very wide ground that to any matter under the IRPA, you can apply for a judicial review. So when you have waited for a super long time and there is still not a decision available, you can certainly file for a judicial review to speed up that application processing. Here is such a case, and let me brief the happenings first. Since 2016, a citizen of both Lebanon and Belgium, Mr. Sowane, has been residing in Canada on various work permits. He is now employed as a wholesale trade manager in the used car industry. On January 21, 2019, Mr. Sowane was nominated for PR by the province of Ontario. On March 26, 2019, he submitted his application for PR to the IRCC and included his son as a dependent. On May 13, 2019, Mr. Sowane's son was requested to complete biometrics, and he completed very quickly. On September 10, 2019, both Mr. Sowane and his son were requested to complete medical examination, and they did it immediately. In 2020, the record shows that the eligibility and the criminality verification were completed. In April 2021, his application was submitted for security concerns and transferred to the IRCC's Etobicoke office. In the meantime, Mr. Sowane's son was requested to provide an updated Lebanese police certificate and complete a new medical examination. On August 6, 2021, he finished these requirements, and Mr. Sowane was exempted from another medical examination. On December 6, 2021, they were requested to update their application forms because the previous ones were out of date after such a long time. These forms were quickly provided after 4 days. Since then, there was no update so far. The estimated processing time for this type of applications listed on the IRCC's website is 22 months. As of the date of filing this application for judicial review, the processing time for Mr. Sowane's file was more than 45 months. And as of today, it has been almost 59 months, which is about 5 years. On June 29, 2023, an officer from the IRCC Etobicoke office, Ms. Serena Sowane, affirmed that the delays in processing Mr. Sowane and his son's applications is due to an outstanding request for information from partners as part of an ongoing security screening assessment, and this is out of the IRCC's control. Ms. Sowane said, in her experience, once background checks are submitted, they can take anywhere from a few weeks to a few years, depending on the complexity of the application and the nature of the potential inadmissibility. But Ms. Sowane didn't mention any complexity or potential concerns in Mr. Sowane's application. Ms. Sowane added, "The processing of Mr. Sowane and his son's application cannot be finalized before the final results of the security screening is available. The judge's analysis is super lengthy, and I will put the link of this case down the video so that you can check it out if you are interested in." In his analysis, he confirmed that in this case, for the court to issue a writ of mandamus, 7 elements must be satisfied. The first one is, there must be a public legal duty to act. In this case, the IRCC has a public legal duty to act, which is to render decisions for the immigration applications. Number 2 is, the duty must be owed to the applicant. In this case, the IRCC must render a decision to Mr. Sowane's application. The third is, there must be a clear right to performance of the duty. In this case, the IRCC obviously has the right to render the decision. And the fourth is, no other adequate remedy must be available. Well, I obviously see no other avenue. Number 5 is, the order must have some practical value or effect. Obviously, the writ from the court would have the application finalized, so that Mr. Sowane and his son would end their wait. That is of very practical value, isn't it? The 6th element is, there shall be no equitable bar to relief. And in this case, the IRCC didn't raise any evidence of the existence of such bar. And the last one is, the balance of convenience must favor issuing the order, meaning that, for example, in the case, the hardship or difficulty can be overcome by the order. We can imagine that Mr. Sowane and his son would be brought very much difficulty or even hardship in their daily life because they couldn't obtain their status for such an extended long time. So all these 7 elements are satisfied in this case. The judge's verdict is, a writ of mandamus is ordered, compelling IRCC to process and determine the applicant's permanent residency application within 90 days of this order. So this is a happy ending to Mr. Sowane's application. But he has been waiting for almost 5 years for an application normally takes less than 2 years. Would it be necessary for every single applicant to wait such a long time before they can do anything? If you ask a lawyer about the judicial review for a writ of mandamus, the answer would be probably yes. But for many real cases, you don't have to wait such a long time before you can do anything. I will discuss about these real cases in my following videos, so stay tuned. Before I put an end to this video, let me ask a question. The Article 72 of the ARPA stipulates that any matter under the ARPA is subject to the judicial review. And let me show you another article of the ARPA. Here is the Article 3 of the ARPA. The objectives of this act with respect to immigration are, subparagraph F, to support by means of consistent standards and prompt processing the attainment of immigration goals established by the Government of Canada in consultation with the provinces. So what does this consistent standards mean? As we all know, in the express entry, the CRS scoreline can fluctuate very much in a short period. For example, in 2024, under the category of French language proficiency version 1, the lowest scoreline was 336. The highest is 478. There is a huge difference of 142 points. I don't know if this is deemed a consistent standard under the meaning of that Article 3 of the ARPA, but I believe many people couldn't obtain this extra 142 points for their lifetime in the express entry. There are so many incidents when the IRCC is implementing the ARPA. For example, in 2023, there were about 700 international students from India who entered Canada with a fake offer letter, and the minister at that time gave them a special exemption so that they didn't need to face the consequence of their own choice, and they can stay in Canada. Is this also deemed a consistent standard as well? In my opinion, probably not, because Canada has already developed a very mature legal system that is able to look at these cases one by one on its own merit. So if these policies of the IRCC constitute a violation of the Article 3 of the IRPA, can we file for a judicial review to correct them? Please let me know how you think about it. I'm Kenny. I believe together we can create a brighter future for Canada by curbing the government's reckless misuse of power. See you in next video.